All right, and this is council. You want to state your appearances?
Council Bitters, Spring County Prosecutor.
And James Gilbert here on behalf of Mr. Case.
All right, and we are here. Looks like we've got a docket call, a show cause, and a motion to quash. You want to argue your motion first?
If I could, Your Honor,
You can have a seat, sir. If you...
Your Honor, I think I laid out pretty much my issues with the case that's against my client. Basically, that I did not, or we do not believe that he is guilty of the interference of a electronic communication device. Some of the things that I point out, I said, I think I've hit most everything in my brief, that they had one phone in the household. The transcript is pretty clear that the alleged victim was not threatened by my client. I think she stated that she just wanted the argument to stop. There was no criminal activity participating at the time. The only criminal activity that did participate was a domestic violence on behalf of the alleged victim. She grabbed onto my client's hoodie. So that was the unwanted touching. And I think we all know if my client hadn't done anything that would have constituted domestic violence that evening, he would have been charged with it. And so the only thing that he could be charged with is that he did not give back the phone for whatever reason she wanted it. Well, even though both of them are using the phone, it's a household phone. And I just don't believe that that brings it up to a criminal type of contact of interfering with electronic device. I believe when we did the prelim, there was some discussion that it didn't matter who you were trying to call, it would still violate that statute. And I really disagree with that. I guess any parent that takes away the child's phone could then be charged with this offense, or take it a step farther. If I'm going to call a school and phone in a bomb threat of some kind, and somebody takes the phone away from me to stop me from doing that activity because it's for my own good, they could then be charged with interference with electronic communication device. I just don't think that's what the statute's there for. And
that may be the willful and malicious element. Is that correct as you interpret that?
That is correct. That would be correct.
Can you help me out with the now? If it's the shared phone, wouldn't be dispositive in all cases, because I mean, back before we had cell phones, there could be a phone on the wall and preventing someone from making a call, tearing it out of their hands or something could violate this. But if he's already in possession of the phone and he's just not giving it to her to make a call, is that different? And well, I guess, is that different?
I would say no. I mean, in my argument, either one of those cases would be, if he picked it up off the nightstand, he's in possession, she wants the phone back, that I don't believe would be interference. And I'm taking even a step farther, is even if he took it away from her, the phone, considering she's not trying to call 911. I'd actually think the way that you've presented it would even be a better case if he was in possession. And that's sort of what this case was. He picked the phone up and then she wanted it back. But even if he had taken it away from the standpoint of, for whatever reason, if she wasn't in any danger, or in the transcript, she said she was going to call 911, but for what reason? I mean, he wasn't doing anything that, police should be coming there from. Either the only thing was that they were in an oral argument. I really hate to think that the police get called every time a husband and wife get into an oral argument. So I don't think either one of those scenarios would violate this statute. And especially, like I said, in this case, I think there's a lot of scenarios where this just wouldn't apply, considering the circumstances, as well as in this case.
So can I ask you to clarify for me, when did he grab or take possession of the phone?
I believe there was a couple of occasions, according to the transcript, and I'm going from memory after reading it last week again, is that, and the prosecution is more welcome to correct me, I don't want to mislead the court at all. He had the phone at one point in time when she woke up, he was going through the phone. And then at some point in time, there was testimony that the phone was on the nightstand and he picked it up from there and had possession of it. And
that second time she was reaching for it to make a call.
that's what she testified to. Yes. And so, again, that's our basis. That's the basis of the motion, and we'd ask the court to quash this case due to the fact, again, that there's one phone. The only way he could dial, and furthermore, he's the one that called 911. He did call 911, so 911 was informed of any incident that was happening in the household. It's just that they weren't called until actually a domestic violence did take place or an unwanted touching. Now, do I agree that probably that was the most egregious domestic violence ever? Absolutely not. But according to the statute, that would have been when there was finally a reason to call it.
And can you help me out then? What evidence are you relying on that this was some shared phone, or was this her phone that she from time to time allowed him to place a call on?
It's in the transcript, Your Honor. I thought I cited the page. I asked in,
Oh, there we go. Yep.
I asked in cross-examination, was there one phone? She said it was her phone, but yes, they both used it. I further asked if he was going to call 911, what phone would he use? Would he use? And she said that phone.
Okay, I see it. Thank you. All right, thank you. Ms. Goodrich, people's response?
Your Honor, I believe that granting this motion to quash would rewrite the statute. There's no requirement on who you have to be calling, whether a crime has to be proven that was committed. There's no requirements as he is alleging. The statute's intended to be allowed to make a phone call without interference by another person. The victim testified that they were in an argument. She wanted to be left alone. She told him, "I'm going to call the police if you don't leave me alone." He still continued the argument and to pursue her. She tried to grab her phone to make a phone call. He knocked it out of her hand so that she couldn't make that phone call. She left because he wouldn't give her phone back. So she left to go to the gas station and make a phone call. The police arrived at that gas station before she could make the phone call. That's the intent. She was trying to make a phone call. He stopped her from making that phone call because they were in an argument. And I think that's the intent of the whole statute, as was supported by the judge in the lower courts, that there is no requirement that 911 be the person that you called. She could have been calling her friend. There doesn't have to be a crime that's proven to be committed before you make a phone call. You're allowed to make a phone call. And that's what the intent of the statute is. And he interfered with that phone call. And I don't think that's disputed even by the facts that's outlined by the defendant that she was trying to make a phone call and he interfered with that.
I agree. It doesn't have to be a 911 call to be interfered with to violate the statute. What am I to make of the maliciously part of the intent, willfully and maliciously?
I think that you look at the context of what was happening around the time that she was trying to make the phone call. Was she trying to call a friend to go hang out and he walked by her and bumped the phone out of her hand? That's not what was going on at all. She was, they were in an argument. He had checked her phone, didn't like what he found on her phone. She changed her password, went back to sleep. Then they again wake up with an argument about the phone. She says, "Hey, I'm going to call the police." He still continues to pursue the argument and bother her. So she goes to try to make the phone call to the police. He knocks it out of her hand to prevent her from doing that. He won't give her the phone back. So she actually has to take her child and leave the house and go to the gas station in order to make a phone call. And that's what the statute is intended to prevent people from having to walk down to the gas station to make a phone call when they were trying to make a phone call from their own phone in their house.
Thank you, Mr. Gilbert.
I don't remember any place in the transcript, Your Honor, that it was knocked out of her hand. I've read through it, and I mean, looking at page 10, where she was testifying, at no point in time do I see anything where he knocked it out of her hand. She said he grabbed it from her at one point, and the other point, when I was doing my cross-examination, she said it was on the nightstand. So I would point that out, and at that point.
Yeah, I guess on page 19, the judge said that Mr. Case smacked or brushed or otherwise used his hand to take the phone away. But you're right, on page 6 of her testimony, she said that he grabbed the phone, he took it from me.
Okay. All right, thank you. Well, on a motion to quash, I have to review the district court's bind over decision for an abuse of discretion. And if there's some evidence that points toward conviction and towards acquittal, then I have to leave that up to the jury. However, whether conduct satisfies the elements of a crime is a question of law that I would review de novo with no deference to the district court's decision. In this case, you know, at some off the record bench conferences, I have expressed to counsel my skepticism about this case, or my, I guess, let me put it this way, the prosecutor would not want me on the jury. But that's not my role today, is not to be a one-man jury. It's to determine whether there's probable cause to allow a jury to decide the case. And here the facts are that the complaining witness testifies that this is her phone, that the defendant communicates with people through a computer at the house, but that he does sometimes use her phone to make a phone call. So she allows him to use the phone from time to time, but I think the testimony is not that this was some jointly owned phone, but it's really her phone. In fact, it's so much her phone that he's grabbing it while she's asleep to see what she's up to, perhaps, I presume, with other men or something is what he's worried about. And that alone is, you know, classic behavior of power and control dynamic of trying to monitor your partner's behavior and catch them in something. And that's a common feature in domestic violence situations. She wakes up, she wants to be left alone. And she says, "Leave me alone or I'll call the police. I'm sick of all the arguing." And then she tries to shut the door. And the testimony was he prevented her from shutting the door. She had said, "Leave me alone or I'll call the police." And then he's refusing to leave her alone, not allowing her to shut the door. So then she wanted to follow through. So he knew that she was going to call the police if he didn't leave her alone. And then she reaches for her phone and he physically prevents her from getting her phone to make a call. Mr. Case then calls 911 himself to report his belief that he's been assaulted, as she's grabbed his hoodie to try to get the phone back from him. So I've expressed some skepticism. Well, I mean, he called 911. However, you know, that's not, it wouldn't surprise me that in some kind of, there's other indicia of power and control in this relationship that, you know, perhaps, and I'm not saying that Mr. Case is a violent abuser or anything, but it wouldn't surprise me if somebody in an abusive relationship as the abuser would try to control the narrative of what 911 is going to learn when their partner says they're going to call 911. And then they think, well, I'm going to stop you from calling 911. I'm going to call them instead so I can set the narrative. And that didn't work out for Mr. Case. So I think on the whole, I can't say that these, as a matter of law, don't meet the elements, even though I'm skeptical of the strength of the case. That's just not my function here today. I can't say that it was an abuse of the district court's discretion to bind it over for trial. I think that there is enough to let a jury decide. So I'll deny the motion to quash. Mr. Case, it is alleged that you are in contempt of court for violating the condition of your bond by having contact with the complaining witness in this matter. You have the right to have a hearing on that allegation, where your contempt would need to be proven beyond a reasonable doubt, and the right to the assistance of your lawyer at that hearing. If your contempt is proven beyond a reasonable doubt, or you admit it, I could jail you for up to 93 days or fine you for up to $7,500 or both. Also, if I believe that you are not following the conditions of your bond, I can revoke that bond. Do you understand the rights that you have and the penalties that you could face?
Yes, Your Honor.
All right, Mr. Gilbert, how do you wish to plead the contempt?
In talking to my client about the contempt, he's going to admit that he did have contact.
All right, so Mr. Case, has anybody promised you anything in exchange for that?
No,
Has anybody threatened you?
no,
Is that your own free choice?
yes,
How do you wish to plead to contempt of court? Guilty, not guilty?
guilty.
So you are ordered as a condition of your bond not to have contact with Ms. Morse, is that right?
Yes,
And let's see, on or about, was it early November? Did you have some contact with her?
I'm not sure on the date, but yes, She came and picked me up from my house to take me to a doctor's appointment for our, she was pregnant with my baby. She came and picked me up and took me to the appointment.
Okay. All right, so you satisfied that factual basis?
I am, Your Honor.
Ms. Goodrich, you satisfied?
Yes.
All right, well, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe you're in contempt, so I do so find. Ms. Goodrich, do you want to proceed to a sentencing sanction on that now, or continue it to monitor, or what's
I'd
your
like to continue it to monitor, Your Honor.
objection to that, Mr.?
Not at all, Your Honor.
So you have no objection to continuation of bond?
No objection.
And so, Mr. Gilbert, given that we've addressed the motion, should we set this for one more docket call?
I think one more docket call, but that could also be a plea cutoff.
Okay. About March 17th at 2:40 in the afternoon. Set that for a docket call, plea cutoff, and a contempt sentencing. Anything further from the people?
No, Your Honor.
Anything further from the defense?
No, Your Honor, thank you.
All right, we'll see you then, Mr. Case. Now, I guess it goes without saying that now you've pled guilty to a contempt. We're going to monitor how this is continuing to go. Any contact whatsoever at all, no matter how benign you think it is, I'll revoke your bond and you'll set. Okay?
Okay. Thank you.
You're all set today, sir. All right, Mr. Gilbert, you ready on Mr. Mason Kozlowski?
Yes.
All right, this is file 25-7106.